So, hello everybody, this is me taking over again. I'm just checking with Danny Sokol. Do you hear me?
I can hear you.
Something? Perfect, so I hand over to you. You're the chair. I think from every subject, at least one person is already present and is already designed as co-host, so he or she should be able to share her or his screen.
Great.
So it's up to you to start.
Okay, so we're going to get started with this session. Thank you everybody for participating. Faces are lovely. Everyone, let's turn on our screens. If you have two-legged creatures in the background, four-legged creatures in the background, let's see them. If people want to come and give hugs to, whoever's sitting next to them in a socially distant way, that's good too. Yes, good to see everybody. We're going to engage. And if the question goes on too long, you get this. This is a wonderful session, and it's a reminder that competition interfaces with technology in ways I think that are really interesting and critical. And one thing I like about this connection of papers is that it's really taking us to the future and dealing with issues in a sense we've seen before about how we deal with professions, how we deal with questions of portability and interoperability, but we're doing it in a sense in a new setting. So the best way for me to explain this would probably be, for those of you who watch the Great British Bake Off, we all get the same set of ingredients, but we all come up with a different showstopper. And that's what we're going to do now. So to make life easier for me and for everybody else, we're just going to go in order of the papers presented. Everyone will have 20 minutes to present their papers. Then we'll have a little bit of Q&A, and I really want some active Q&A. So the first paper is by Christina and Laura, Regulation, Competition, Law, and Experimentalism, the case of fintech sandboxes. And I'll let you know when you're getting close to running out of time.
Okay. Okay, thank you very much, Danny, for the nice introduction. So we're extremely happy to discuss with you today, Christina and I, our ongoing research on regulation, competition law, and experimentalism. And as you can see from our title, our idea was to select a case study, specifically the one of fintech sandboxes, to test the correlation between competition and regulation, which indeed can have different forms of balancing act toward experimental framework like the one of regulatory sandboxes. In particular, as you can see from the outline, both our research paper and our presentation lies on three main pillars. First of all, we try to answer to a research question, which is the impact of structured experimentalism, such as regulatory sandboxes, on competition law, specifically in innovative markets such as fintech one. The second pillar is indeed trying to frame such regulatory sandboxes within the debate of experimentalism. And last but not least, we were considering the consumer interest in the context of regulatory sandboxes. So I will start by quickly framing the phenomenon that I'm sure you all know what a regulatory sandbox is, but it's important for us to have a common definition to elaborate more on that. And we consider that a very broad and general definition can help us in framing the debate. In particular, we can consider a regulatory sandbox as a framework, which indeed is set up by a regulator to allow live testing of innovations. And of course, the peculiarity of regulatory sandboxes is that we deal with a controlled environment. That means that the regulators are supervising them. And the beneficial effect for those that are admitted in the regulatory sandboxes are having special exemptions, exceptions, and even allowances, of course, for a limited amount of time, and again, under the control of the regulatory supervisor. So just to see together how is the situation in Europe, we can see that we currently have 7 regulatory sandboxes operating in Europe. And of course, we all know that the pioneering model has been activated by the FCA in the UK in 2016, and then other states are proposing for the regulatory sandboxes. And in our opinion, even if right now regulatory sandboxes are mainly operating in the fintech market, we should consider such a model as a potential model for activating regulatory sandboxes in other contexts, in other scenarios. What is the reason why we think it is needed some research on the balancing act between regulation and competition within such a form of experimentalism, which are regulatory sandboxes? Because according to regulatory authorities, competition, consumer protection, and innovation can be all safeguarded by regulatory sandboxes. Just to quote the FCA regulatory sandboxes I was referring to before, we can see that the regulatory sandboxes activated by the FCA is willing to promote innovation while safeguarding effective competition in the interest of consumers. And of course, this can be made by a specific measure, like limiting the amount of consumers accessing the sandbox, selecting them on basis of specific requirement, limiting the time of duration of the sandbox, and so on. But interesting enough, there is this idea in the statements of regulation in the case of regulatory sandboxes that they can foster innovation while safeguarding regulation and competition. And of course, the primary goal of regulatory sandboxes is promoting innovation and only subsequently safeguarding consumer and competition specifically. And of course, this opens several different debates that we will address that we are addressing in our paper that we can focus on. For example, the coexistence of innovation and competition that has been very well framed yesterday in the first panel of our ASCOLA conference. So now, starting from the first pillar of our paper and of our research, we were trying to figure out what are, let's say, the elements that should be addressed by competition law scholars. In our opinion, we miss a full exploration of the relationship between competition law and regulatory sandboxes, because if from one side we do have regulators assuming that regulatory sandboxes are framework that can promote both innovation and the competition, from the other side we have a very peculiar way to foster competition. And this is where we identify a paradox, and that, you know, we identify the reason why we think we should elaborate more on regulatory sandboxes and competition. First of all, because per definition, regulatory sandboxes have barriers to entry. So the participant, the private companies attending the regulatory sandbox are selected on basis of parameters. So in a way, we can identify a paradox, because the idea is that the regulator is protecting competition while excluding companies. Of course, again, they can decide to adopt corrective mechanisms just to be sure not to distort competition, but this is extremely different from the traditional approach we have toward competition law. Second, there is this idea of having an ex-ante perspective, while the traditional application of competition law is perceived in an ex-post perspective, verifying the conduct carried out by companies and identifying if there is a boundary which is infringed, so a competition law provision which is infringed. To make a long story short, in our opinion, regulatory sandboxes represent a context in which the boundaries between regulation and competition are much less clear than in other forms of experimentation. And of course, another element is that we consider that the spread of regulatory sandboxes confirm the trend we are witnessing toward a major experimentalism. Of course, we were trying also to assess what could be those conducts happening within a regulatory sandbox that can represent an infringement of competition law, and we specifically discussed the potential information exchange between competitors which are indeed operating in the same regulatory sandbox, and we were discussing about the difficulties in defining the relevant market in this specific case. So just to summarize this first part of our presentation, we consider that we are in front of a sort of a paradox. And in order to explain well this paradox, we think that we can share another definition of regulatory sandbox. Why? Because a regulatory sandbox can be also defined as a government-granted privilege. Indeed, those that are admitted to this specific sandbox, to this specific space, will have a beneficial effect, such as exemptions, reduction of regulatory burdens, and so on. While those that are not accepted or that are not included in this form of experimentalism will not have such a beneficial effect. So in this sense, we think that there is such a paradox because regulators are stating that regulatory sandboxes represent a balancing act between regulation, competition, and consumer protection, while from the other side, the way in which they are carrying out such a competition law protection is very peculiar and is still limiting the privilege to those that are admitted to this regulation, to the regulatory sandboxes. In this sense, we think that to summarize where the sandbox paradox is lying, we can discuss about this selection process that is, of course, regulator driven. So the next step of our research is framing such a specific form of experimentalism, regulatory sandbox, within the debate concerning experimentalism in general. And I leave the floor to Christina to proceed with our elaboration.
Okay, thank you, Laura. Can you hear me?
Yes, we can hear you.
Okay, fantastic. I would like to proceed on the way opened by Laura by discussing two main points in the time we have. The question we pose follows. Would this innovation require a new approach in analyzing competition for new markets, for new services and products? And the second question, who is the guinea pig for this kind of experimentation? Obviously is the consumer. So in the last 2 decades, in many areas of social sciences, we have embraced this experimentalist turn. It is quite more common in law, in sociology, in many areas of the law, and as well other social sciences. I think it's important to have this point very clear with respect to the relationship with competition law, in the sense that for experimentalism, we have in mind, in theoretical terms, two different approaches. One is based on experiments and the other one is based on empiricism. Obviously, competition law traditionally grounds on empiricism and market analysis and relevant market definition. But what is more interesting is the use of experiments. We have tried to examine the state of the art in the area, and we have discovered that there are many cases of experiments to use to define markets or to analyze competition in merger cases. More recently, what has been interesting is the use of this theory of experimentalism governance in the EU that has been elaborated by Zabel and Zeitlin with respect in competition law, specifically with respect to antitrust enforcement. Zvetiev has attempted to apply this theory to antitrust enforcement in the sense he sees enforcement as a sort of deliberative process based on shared learning among national competition authorities, is a way of trying, testing, reviewing, and monitoring in such a dynamic process. But our perspective in the paper is different, because we are interested to discuss if structured experimentalism, as the case of Sandboxes confirm, could be a model in approaching innovation. Basically, one may question if this is good for all, in the sense we try to use such a sort of mechanism to put together innovation, competition, and consumer protection. At the same time, we see that it is the heart of divining in a certain sense, because we are talking of nascent markets for new services. So the authority has to foresee the impact of potential competition in the future. In a competition law strictly analysis, we see that the main risk is about collusion, in the sense that there are many safeguards in designing the sandboxes, but there is obviously the risk of new forms of organizing and implementing collusion, also in cases where firms really know about compliance measures and are aware of risk of exchanging sensitive information while in such a protected environment. As Laura has stated, this kind of approach to competition for nascent markets is based on ex-ante enforcement. That is a way to say we focus on the beginning of a new market in order to fix the rules at the beginning, in order to avoid that, as it happened in the past, we all know, we have, in a very short time, observed a concentration of power. So we go at the very beginning. I don't know how much time we still have, but I think what is also relevant here is the fact that
6 minutes, by the way, so you're very much on schedule.
Okay, thank you. I would like to be on time. So we see here another interesting aspect in analyzing this as an approach to competition. It is the idea of using sandboxes, using this sort of experimentalism to offer a sort of scientific analysis of the state of competition based on experiments. So basically a sort of protected environment when you can avoid the political stake. But indeed, our point here is that obviously experimentation is not a neutral activity. The way you select the entrance in the sandbox, the way you design the sandbox is not neutral. So this ideology of relying on scientific methodology probably is a good way for authorities to say, we have something based on scientific method. So it's very sound and it's not political, but in our view, this is just, a way of presenting the sandboxes that is not so easy. Is a process, this kind of mechanism that grants to authorities the big power of learning with a view of changing. So is a sort of epistemic learning about new services, quite often very complex because based on innovative technologies. It is also some sort of political learning because they involve consumers in the box, so they can have some stakeholders' views. So how far this would be a solution for policy making? So it's not just a descriptive tool, but a normative tool. We discussed this point by thinking to the fact that this is a typical problem when you're doing experiments, is the problem of the external validity. How can we generalize what happened in a sandbox to a real world economic phenomena? And from the small sandbox to the market, is it difficult to use this? This could be used as a policy instrument. We stress this only if you do a very sound sandbox, in the sense with a very robust framework designed by authorities, and you have a very credible experimental outcomes. The second point, who is the guinea pig? Is the consumer. Consumers indeed will be selected to enter the sandbox. The question is, all consumers, it depends on the sandbox. So in our analysis, we have discovered that depends, it could be that sandboxes include final consumers in some cases, depending on the services. In other cases, they select more sophisticated consumers. So obviously, the more the retail consumers are in the sandbox, the more restrictions regulators will typically impose to protect them from the risk. Consumers have benefits, sure, they have new services, so diversification of services and actors. Some scholars also stress the link with the development of new services that could be useful to overcome the exclusion, the financial exclusion of certain groups of consumers, but many risks. On this side, we see a data protection risk. Obviously, as our colleague, Professor Di Porto, stressed in a previous session, these sandboxes always deal with innovative financial services that use data in an intensive way. So you manage data in that environment. This is good, could be good. You can personalize the services and have tailored pricing for consumers, but on the other side, obviously there is a potential risk of consequences that adverse consumers, for example, price discrimination, because we obviously know about preferences, we know about their behavior, and finally, at the risk of discrimination, not offering certain services to consumers because the bank or the insurance recognize that this group is too risky. There are certain safeguards, and it is very interesting in studying sandboxes to see that they provide for collective or individual redress mechanisms for consumers, but it is not clear to date. We will not be able to date to have a clear picture from the existing sandboxes about the importance and how this redress measure would be designed in the near future. If I still have time, I go for the conclusion with Laura, and I finish.
There's
here.
always time for the conclusion.
Fantastic. A few points. I don't know if Laura is willing to get to intervene on this. We think that it is not competition in the sandbox the key point. The point is innovation, because it's the ideology that innovation is good, innovating is always good, and that we fear that competition may, you know, impede innovation. So we have to find a way to do a competition analysis, but the goal is innovation. Is it a good way of proceeding this experimentation? If you believe that the scientific method is the right and the best paradigm, yes. We stress that it is not just a matter of science, as we discussed yesterday, is a matter of politics, and you can decide to, as a government or as an authority, to go for one solution or the other, not because it's the more efficient or the more scientifically sound because of data, but because it's something that is the best solution for society in terms of well-being, consumer welfare, and so on. And then we see here a case that is also interesting for other perspectives, like the blurring boundaries of regulation and competition. In the past, we have been always say they are very different. Here we have this overlapping scope in the instrument. And then what about consumers? Consumers will be our guinea pigs in sandboxes. We hope that they will receive adequate protection. To date, it's difficult to say because this is a new mechanism. We are trying in our research to verify how they are selected, how skilled they are, and how about redress in case of failure. But this is something that is going on now, and we are carefully monitoring this. So thank you for your attention and for your time.
Thank you. That's great. The way I'm just going to go is presentation to presentation, and then we'll have some time for questions at that point, and that way questions for the first set of presenters doesn't bog down the ability of the last set of people to be able to have time to present. So I guess I probably should have laid down the rules beforehand, but I guess I'm now responding to how to play with the regulatory sandbox and dealing with the experiment. Okay, moving on. We have our next paper by Vela, Rethinking the Legal Profession's Regulatory Regime. Is Lawyers' Monopoly Justified in the Era of Legal Technological Innovations? I think this is something that afflicts many countries. So this is a very exciting presentation. And thank you also for the last presentation. I thought that was really, you did a good job.
Okay, thank you so much for the opportunity. So I'll go ahead and share my screen. Would you share it for me? You can say cannot share.
It should work now.
Okay, let me try again.
So when I made a joke earlier about interoperability, I didn't think it would be on this issue of, you know, who can share. Is it working? Yes. Okay. Excellent. So
is it working now?
This is not the Apple ecosystem dealing with Spotify.
Okay. So this.
Excuse me, Vella. Can I just
Okay.
interrupt you? Please open your PowerPoint first and then share your screen, because otherwise we can't see it.
Okay. Like that?
Not yet.
It has been posted on the other side, I think.
Could you just stop sharing and then open
Okay.
the PowerPoint and then restart sharing, because then it should work.
Okay. Sorry.
That's perfect now.
Okay, thank you. So the question of whether lawyers have exclusive monopoly in the provision of legal services is one of the areas that has attracted a lot of criticism and a lot of discussion. So this is part of a paper I presented sometimes back in 2018 and also in 2019. So in this case, as we know traditionally, since time memorial, lawyers enjoyed exclusive monopoly in the provision of legal services. So it's only a lawyer who has been trained, who has the basic legal education, that can practice law and also provide legal services. But technological innovations or technology broadly has really disrupted a lot of markets, whether social, economic, or political areas. And one of the areas that is undergoing this disruption is law. But then lawyers have always thought like the kind of disruption that's going on in the legal market is more of evolutionary, that it wouldn't entirely disrupt the entire legal market. So I'll take you through the question whether lawyers should continue enjoying exclusive monopoly, or to what extent they should, the disruptions that are going on through the legal market, and then the impact of technological innovations, and some policy recommendations that I think of. So first of all, I'm using the word monopoly to refer to the extent that lawyers control the largest market for legal services. We have other alternative service providers, but lawyers really enjoy the monopoly. And there's some theoretical justifications for lawyers having monopoly. And one of them, which is based on the public interest theory, is in order to address market failures. And one of them is information asymmetry, that is believed that the client doesn't have much knowledge or expertise about the particular legal issue, and therefore the lawyer is the most placed to provide the client with this information. And another one is that it protects consumers in a way that consumers get quality legal services, other than just any person who has not gone through the legal education can provide. And discussions are that it's this monopoly problem, which especially in accordance with the legal business model, lawyers do not have the incentive to innovate, because these models help them to charge higher prices for what they offer. And because they're the only ones offering, the client doesn't have any option. And because of this higher cost, a lot of segment of the market is not able to access justice or to access legal information or even to access the lawyers. And this one is affecting all markets, whether in developed or developing countries. So because of this problem in the legal profession, it has been disrupted in a number of ways. One is that clients are demanding for lower costs, and they're also demanding for an alternative use of fee models beyond the billing model. And also there's emergence of other alternative providers entering the market, which are non-law providers. And there's also an increase in number of graduates entering the market. That means we are having a lot of competition because of the increase of law graduates and in-house lawyers. Therefore, it's making the market to be a bit bigger. And then the democratization of information. Because of technologies that are coming in the legal market, clients are able to find information online. And this information includes information on the lawyers they can get in touch. So the bespoke kind of communication whereby you could just be referred from one lawyer to another is fading and so on. And then there's also a rise in self-representation. And these clients that are seeking self-representation need information. And that is what some of the legal technological innovations are trying to provide. So when I go to the exact impact of the legal technologies, the legal startups within the legal market, is that they're bringing with them competition. And that encroaching in areas that were once exclusive to lawyers. For example, document review, legal research, predictive analysis are some of the areas that legal startups are able to provide. And therefore, this means that lawyers also do not have the exclusive opportunity to just provide these services. And because of this competition, the reserved tasks, the reserved tasks that lawyers used to have exclusive monopoly is shrinking, and it's diluting the lawyers' monopoly. And we expect the lawyers to react. And there are two ways in which the lawyers will react. The lawyers will either change, adapt, or they will resist. And therefore, in this paper, I want to focus on the second part of resisting. So if lawyers want to resist this, what will they use? They're going to use the regulatory framework. How are they going to use this regulatory framework? One is to bar entry of new innovations. On the justification that these lawyers are the only people who have the superior knowledge to provide legal services. And another way they're going to do this is through price regulations, because the legal innovations seek to provide lower costs. And therefore, because the price regulation, especially in most of the advocacy regulation order, literally states what amount lawyers are supposed to charge and not go beyond that. And therefore, they are going to use price regulation. And another one is having reserved tasks for lawyers. So those are some of the things that I'm looking at. How are lawyers trying to justify the monopoly? So the question has been, are lawyers more superior? There's an article about that. Is the monopoly justified? And my argument is that the market has really changed. And because the market has changed, the legal profession also has to change. And if the outcome is to protect consumers, then we have to understand what are the needs of the digital consumer. Has the legal market as it's now, or has the legal technological innovation brought some changes? Let's talk about information asymmetry. And when we talk about information asymmetry, I want us to also think about digital divide between developed and developing countries. So that's why in this particular paper, although we've had a lot of discussion about this in the US, in the UK, in Canada, I would like to discuss about what is really happening in developing countries where there's no, where we're having a lot of digital divide and not everyone is able to access internet and so on. So my argument is that there's need to demarcate. And when I'm talking about demarcation, I'm not saying that some services should be exclusive for legal technologies or some services should be exclusive for lawyers, but there's a need for them to complement each other. And therefore, there's a need to determine what are those tasks that the legal technologies can do. And a lot of literature is showing that legal technologies can only provide services or information that is structured. We are talking about past judgments, we are talking about structured documents, and then when it comes to cases whereby we need more human interaction, we need more emotions, and so on. Bonding, cases such as court presentation, plea bargaining, cases like negotiations, fact investigation. These are cases that we cannot argue that the machines are able to do that. But both machines and lawyers can complement each other in order to provide better services for consumers. And therefore, this paper, what I want to bring out is how we can have a healthy competition between innovation and between lawyers, so that we are creating a balance between competition and innovation in order to provide the consumer with better services, with lower cost, and so on, and finally, with access to justice. And in that connection, when we're accessing that, we are looking at the difference between what legal services technologies can provide and what lawyers can provide, and we are balancing the risk associated with also legal technologies. This such as, if you look at most of the websites of legal startups, let's say like LegalZone, it provides that we are just a self-help service and we are not providing legal advice. Does the consumer really understand the meaning of these conditions? Has the information asymmetry gap been addressed by the legal technologies? And if the legal startups are not liable for this, then how can we protect the consumers? So I would say that it's not a matter of self-regulating the legal profession. It's a matter of looking at those issues whereby either they're unnecessarily restricted or they're not proportionate in meeting the public goods that our consumers need. And in that connection, I want to look at the Kenyan scenario because most of the papers I've read all refer to the US or Canada or UK in the developed region, and contextualize the Kenyan scenario within a developing country regime. And therefore, I'm taking this from an antitrust perspective, and therefore, I would review the Kenyan legal system and the key developments that the legal market has gone through in order to understand and bring out the key changes and what lawyers are able to do and what the legal technologies are able to do and the needs of the consumers at this specific time. And therefore, finally, as I move on, I just want to say that there's no study by any competition agency that I know of that has really done a market inquiry or a surveillance to just understand what is on the ground at this specific time. And also, there's also no study that has done a survey or something of the sort to determine what really consumers in the digital era want. And there's no study that has been done to determine what are the risks and the harm associated with the use of legal technology and if they enhance the consumer welfare. And therefore, I believe that this is the moment now to assess the market structure of professions that are highly regulated here. And understand the link between competition that these technologies bring within the market and address a healthy competitive market. Do I still have more time?
Okay, that's great. So actually you're 3 minutes under, but that just means another question for you when we get to question and answer. Moving on, Michal, competitive effects of GDPR. I don't see her here. I think that may be a typo because I didn't see that as part of what we were supposed to be doing, but it is on the website. So we'll, oh.
As long as I know, it will be up to Thibaut Schreppel.
Okay, that's what I thought, but the website said differently. So Thibaut.
Okay, I'm sorry about this.
No, it's okay, it's okay. Thibaut, we're ready for you then. Let's hear about all of the glories of fintech.
All right, so let me share my screen. So if you can hear me and see my screen, that's perfect. So first of all, I want
to both.
Perfect. To thank the organizers. I can only imagine all of the implications to organize such an event online. And I also want to address, I hope that everyone is doing okay. And I have especially some thought for Zlatina, who's in the room right now with everything that happened in Zagreb recently. So that being said, I will move on to my presentation and I will discuss today blockchain and antitrust issues. So something a bit broader than just fintech, which is one application or could be one application of blockchain. And the theme that I've chosen for the presentation are, as you can see, UFOs. And there are 3 reasons for that. The first is because I think UFOs are actually quite cool. So I thought, why not? The second reason is because I recently had a conversation with blockchain developers, and I was discussing and employing the term legal fiction. And I realized after more than 1 hour, then every time I pronounced the word legal fiction, they were hearing a fiction like Harry Potter or something which is not real. And then I realized that it was actually my bad from using the terms that we use between us lawyers and wanting to reach to a different sort of population. It was my fault not to make myself clear. So today I've decided to use the term legal fiction as I will explain in the 2 sense of the term, the legal one, but also the term fiction in the Harry Potter way. And the third is because hopefully you won't look at me in 20 minutes as if I was a Martian and discussing issues that you think are coming from another planet. So that being said, in a nutshell, and I want to start there, what I will explain today, or the point that I want to make, is that the firm is the pillar for competition law. And I think we can all agree on that. It has been the scope and the glasses through which we are seeing competition. We are not looking inside the firm. We are looking at firms and markets, but we have difficulties looking at a bunch of different markets at the same time. And the point that I want to make also is that the firm in antitrust is exactly how it was defined by Ronald Coase in 1937. And you could say, well, it's a proof that it's a great concept. But I also think that it's a proof that we probably need to either to change what we mean by firm or to use other concepts, because it will be complicated to capture what's happening right now in the digital sphere. So on that basis, then I will prove and to show you at least that blockchain, and here today I will mention public blockchain, and I will be more than happy to discuss differences if you want. Public blockchain do not fit within the firm. They are not firms, they are not markets, which means that the basis for modern antitrust law is not working anymore. So on that basis and against this background, and that's my paper, I've written about another way to try to capture blockchain. Otherwise, you can't apply antitrust, at least to the layer 1, which is to the entire community. And the way to do that, I believe, is to create a legal fiction, which is not a firm, which is another legal fiction You could call it whatever you want. I will call it the nucleus. And if you don't do that, well, I believe that you can't even think about antitrust when it comes to those blockchain. So that's the logic of my talk today. But first, I want to go back to that idea of a legal fiction. And so to be clear, so to make sure we're all on the same page when I discuss what is a legal fiction. So legal fictions, first of all, of course, Martian are not legal fiction, although you could say, yes, this is a legal fiction. But a legal fiction has been defined several times. And on purpose, today I'm using Wikipedia because it is decentralized. A legal fiction is basically a fact that you create and you assume that the fact is true. And the reason why you do that, it's because it is convenient for you to assume that it is true. So if I move on a little bit, there is one book, if you want to read about legal fiction, which is a defining book in the field. And that book, as you can see from the cover, it's called Should Trees Have Standing? It's a fascinating book. In the first few pages, is Christopher Stone is explaining how he came up with the idea that actually trees should be granted rights. And for that, you need trees to be seen as legal fiction. So it's quite a funny story. I'll let you read the book if you want. The book was authored and published in '72, and it was a bit written in a rush before the Supreme Court were actually taking a decision on that issue. But since then, it has been written and publishing different editions. And so it goes back to that idea of legal fiction and explain that a legal fiction must be able to do three different things. The first, institute action on its behalf. The second one is that if you try to measure injury, it should be the injury of that legal fiction and not the injury of something else. And if you are then awarding compensation, you should be able to award compensation to that legal fiction. So if I go back to our field of antitrust, it means that markets are not a legal fiction. You cannot say there is harm to the market and then compensate the market. It doesn't mean anything. But a firm is a legal fiction. And so, of course, the firm is one of the oldest legal fiction. I went back to the rules of the British Parliament in the 15th century, and already they were saying, yes, basically a firm is a bunch of persons, but that is something that we deem existing because it is convenient. And you have that paper by Stanford Cheney, Corporation is a person, written in '87, if you want to read more about that. So that's the idea of a legal fiction. And then when I was doing this research, I asked myself two questions. The first question is, how do we create a legal fiction? So for that, there are three ways. For a matter of time, I won't detail those three ways. But of course, it's not that one day a judge could say, okay, I'm going to create a legal fiction because this is convenient for me to do so. It has to go through a process. And the second question I asked myself was, well, if a legal fiction is something that is convenient for applying the law and in the end organizing society, why not creating thousands of legal fictions? And there are several reasons for that. The first, and in the word of Jeremy Bentham, is the idea that a legal fiction is the stealing of legislative power. So indeed, a court would say, this exists because I find it to be convenient. But generally, if it is done in a court, the parliament might disagree, so there is a risk there. And of course, when you create a legal fiction, the goal is for you to achieve a result, and you want that result to be coherent with other results coming from other legal fiction, and you have to be able to systematize your results. So those are a bit of the issue. So that's the idea of legal fiction. And so then I went on studying, all right, what are the legal fictions that we are using in the field of antitrust? And the number one legal fiction is the firm. So of course, all of us know what a firm is. But the point that I want to make is that we are defining a firm in antitrust, again, based on Ronald Coase. So in that paper, if you haven't read the paper, it's only 20 pages. I promise you there is no mathematics, no formula that as lawyers we pretend to understand, but we really have no idea. And that paper was actually written when Ronald Coase was 21 years old, only 20 pages long. And he ended up winning the Nobel Prize in economics, as you know. and the Nobel Committee mentioned that paper first for the reason why he got the Nobel Prize in Economics. And in the paper, he asked a very simple question, very elegant question, which is why I think it's such a good and important paper. The question is, if markets work so well, why do we have firms? Why not everyone being just on the markets and transacting on the markets? And his explanation is quite simple as well. His explanation is that, well, when people come together within a firm, sometimes, not always, but sometimes, for certain transactions, they can save costs. So now we know that this idea is called transaction costs, which are all of the costs that you need to engage before transacting with another person. But at the time of the paper, it was not mentioning transaction costs. He was calling them advertising costs and marketing costs. But that's the very basic idea. And the way and the reason why firms may allow you to save costs is because a firm is top down. You have a CEO, a board, whatever the structure. They are giving orders, and those orders are being executed. And those orders, in the end, trickle down the firm. And for that reason, you save costs. And indeed, if I work in the same firm as someone else, I go to that person and I ask that person to do something for me. If I'm the boss of that person, I know that this person will execute. I know that there is no need for me to sign a contract. We're part of the same firm and so on. And so in the word of Ronald Coase, firms save costs because they are helpful to direct the resources. So that's the very basic idea, the top down. And so then I went to antitrust literature, and especially the decision in the US and in Europe dealing with a firm. And I tried to study whether or not control, the idea of control, top-down control is something that matters in antitrust, or if we also take other criteria into account in defining what is a firm in the meaning of antitrust. And the answer is that we do not take anything else into account. So I've listed a few decisions over here. Again, more than happy to discuss, but I won't go through all of them. But I mean, we all know in the room that the legal form doesn't matter in antitrust, right? This is the first thing that we teach our students. If there is a subsidiary and the subsidiary is controlled 100% by another undertaking, they are deemed to be the same firm for antitrust. So modern antitrust is based on Ronald Coase, the work from 37. So of course, and this is why I put a picture here of Oliver Hart, who also ended up winning the Nobel Prize in Economics 2 or 3 years ago, 2016, I believe. And Oliver Hart worked on the theory of incomplete contracts. And his idea was to say, well, the firm is not only convenient because you could save costs, but it is convenient because in reality, things happen and you cannot always put everything in a contract. But if you are within the same firm, you will be able to manage to find a solution. And then I thought, potentially we use that in antitrust. And again, the answer is no, we don't look at that to define a firm in the field of antitrust. I was lucky enough to discuss those issues with Oliver Hart. Of course, he regretted the fact that that theory is not used in antitrust, but it is not. So that's the very basic idea. And then I thought, so, okay, we define the firm according to Ronald Coase, and it means that we have a legal fiction to which we can apply antitrust. But I actually believe that this is more than that. The firm is helpful in the way we apply antitrust. And if you think about it, whether it is Sherman Act Section 1 or the Article 101 of the TFEU, we say that there is a collusion between two firms if they are separate entities. And otherwise, we know that if they are part of the same firm, it is impossible for oneself to collude with oneself. So for that reason, the firm is also helpful in the way we study Article 101. Same for Article 102. You cannot abuse yourself. So it means that if one company is abusing its own undertaking, it might be lots of different issues, but this is not antitrust. Everything that happens within the zone of control is not antitrust. So that's quite easy to understand, but this is why Coase theory is so important. But then, and I will finally come to blockchain. Of course, I believe that we have a little problem with the theory of the firm trying to apply that theory to blockchain. And the first is that I need to explain that why blockchain is not a firm and is not a market. There are several reasons why, but the number one reason is that in a blockchain, at least in a public permissionless blockchain, there is no vertical control being applied, and even less a centralized form of control. Of course, also all of the contracts have to be complete. If you write a smart contract, then it is immutable. You cannot change it. So it creates tons of different legal issues. And the reason why we trust one another in a blockchain is because of the architecture of the blockchain, and not because we know that we're going to be able to find a solution if something happens in the future, which is, again, Oliver Hart. So the blockchain is not a firm. The blockchain is not a market as well. It's not a market because the first is that, of course, everything in a public blockchain is open access. So there is no need to discover the price, which is why we deem market to be efficient, because it is a discovery procedure. And also another difference is that in a blockchain, you actually can access everything that has been ever recorded in the blockchain. And that information is very valuable, and you don't have that information on the market. If you go to someone and try and negotiate a price, you have no idea about the price that this person has negotiated with other persons in the past. So blockchain is not a firm, is not a market. And where it becomes a bit more tricky is that none of the 4 categories of participants in the blockchain, core developers, users, nodes, and miners, if you have a question, again, happy to explain what they do, none of them control the others. And that's really something that is new. Blockchain was designed this way in reaction of the financial crisis. The idea of blockchain was to create a technology that governments cannot eventually size. And this is why blockchain communities trust one another. But of course, the law can also be helpful to trust one another. So here it creates an issues. Also, I won't discuss that, but then I try to see if blockchain were fitting in the category of other legal fictions, such as association of undertaking, and the answer is no, for a bunch of different reasons, namely that in a blockchain, you don't have economic actors coming with one another. Potentially some participants have no economic activity, therefore there is no association of undertakings in that sense. So of course, what you could do without a new legal fiction is apply blockchain to that guy. So this is just a random guy. So you can always apply antitrust to one specific person in the blockchain. But if you want to capture what's happening at the blockchain level, the dynamic between blockchains, then you need to have a legal fiction. And so for that reason, I went on to try to see how we could create a new legal fiction to capture those public blockchain. And so that's the idea of the paper. Of course, if you want, you could download the paper. If you have questions or comments other than the Q&A, feel free to send me an email. But so my idea was to detail something that I call the theory of granularity. And the reason why I use that word is that granularity, not in the social science, but in the hard science field, defines the size of the smallest element in the system. And I believe that for blockchain, we have no choice but to go through the size of the smallest element in the blockchain to try to create a legal fiction. And the reason why that is, I think, is quite easy to catch. In a firm, since it is a vertical control, you need to understand the top of the firm, and that's it. In a blockchain, the control, if there is control, is horizontal. And for that reason, you need to understand everything that's happening between those elements on the horizontal level. And so for that reason, that's the theory of granularity. You need to enter the blockchain as Coase entered the black box of the firm in 1937. So again, I only have 4 minutes left apparently. So I won't go through all of that. But that's a table that I created, and it took me a lot of back and forth, especially with Vitalik Buterin from the Ethereum Foundation to try to get it right. So those are the 3 categories of participants. I have eliminated the nodes here, and the 4 constraints being exercised. And so what I've done is that I came to the conclusion that none of them can actually exercise control, because of the way the blockchain is designed, the markets, the laws, and so on. However, what you see for every blockchain is that at some point, some users of those categories will come together, and together they will collaborate to achieve the survival of the blockchain. And from their collaboration, of course, it means that they are not, they can avoid the constraints being exercised by the other because suddenly they collaborate with one another. And those, I call them the blockchain nucleus, so the very center of the blockchain. So here I detail why they can control the blockchain, but it's not control in the sense of the firm. It's a horizontal form of control. But in the end, and again, happy to go through that, what you come up with if you study blockchain at that level is that there is a nucleus for each blockchain, and that nucleus actually has the power to stop illegal transactions to some degree. Not equivalent as the firm, but to some degree they can control what happens. And here you have your legal fiction. Indeed, you don't want to create a legal fiction and say you are liable for something that you cannot possibly control. It wouldn't work. But here it works for the reason that they can actually coming together, create a new form of control within the blockchain. So that's the idea. The usefulness of that, well, as I explained, here you can see that's the firm. We say everything that's happening within the firm is not antitrust. It's antitrust only for the effects outside the firm. If you don't have a legal fiction within blockchain, you have no inside and no outside. Here's the problem. And I think if you recreate a legal fiction, you solve that problem. Again, then I went through all of the steps of antitrust, and I show in the paper how using that theory, you could actually recreate a relevant market, determine market power, analyze the practices, assign liability, and so on, for reasons that I detail in that paper. But I want to finish and conclude for the 1 minute that I've left, if I'm not mistaken, with a few challenges, because of course, this is just the beginning and there are lots of challenges. And I think the number one challenge is to convince authorities that we need to enter entities. So it means we need to enter the firm, we need to enter the blockchain. And if we don't do that, we will miss on a big part of what's happening. And so I wanted to ask you the question, but of course, using Zoom, it's not very convenient. But the number one reason why people are not using Facebook, they say, is not because they have another service which is better. It's not because there is no data portability and they say, oh, but I would like to be able to share my pictures. It's none of that. The number one reason is because people distrust Facebook. And that's a study that was conducted by The Verge and published in December of last year. 46% of the people don't use Facebook because they don't trust Facebook, which means two things. First, we have a huge blind spots in antitrust, and this is why Mark Zuckerberg must be so happy, meaning that everything that's happening within the firm, we pretend it doesn't exist. If we do that, we will miss on anti-competitive practices, and for that reason, and here I'm a bit extending the scope of blockchain, we need to enter the firm. It also means that we will miss on some efficiencies creating within the firm. And that's the book of Nicolas Petit was presenting on the book this morning. And he studied really the financial report of those firms to find out that actually sometimes they feel competitive pressure where not looking inside the firm, we will not see that pressure. There are a few more technical challenges, which is more blockchain. So I won't go through all of that today, so you won't look at me as a Martian, hopefully. Key question, can we create a legal fiction for Martians if they ever come to planet Earth? Sure, we could do that, but it means that they then going to be able to start actions in our legal courts and claim for damages. So this is more the general picture, but one day potentially we'll define markets, taking lots of planets into consideration, and it will be beautiful. If you want to read more, I've created a website, blockchainantitrust.com, with all of my publications in the field. And again, look forward to the discussion, and thanks a lot for organizing this event.
Great. Well, that gives us a lot of time for questions. I see we don't have a hand raising option. So what I'll do is I'll just go based on the list of people in chat if they want to ask questions. And I saw that some people already did. Some people. So the first one I saw was Nicolas. You had a question. If it is about your book, and whether or not he represented it correctly, that's more a comment than a question, but I'll take question really means question.
Are we going through my presentation first, or questions would be after that?
Sorry, I was on mute. We'll take questions as they come up. Oh, I'm sorry, that's right, I'm missing one. Thank you. I was like, we have way too much time. How did that happen? And now I know. So Julia, yes, why don't we do your presentation first, then we'll go to Nicolas because he clearly has something that he would like to intervene with. But we'll let you go first. And then that way, you know, we'll keep him in suspense.
Okay, perfect. Thank you. So let me share with you all this. Can you see it properly? Okay.
Yes, everything's fine.
Thank you. Well, so first of all, are you saying the presentation?
We can see the title page, yes. Blockchain,
okay.
Trust and Trade.
Okay, you're saying the title page, perfect. So now I'm having a little bit of an issue here. Okay. I'm just trying to, just a second, trying to. Okay, so now. And we're good. Well, first of all, let me start saying that I am delighted to be here today. This is my second time as a speaker in a ASCOLA conference. Most of all, I'm honored to share this panel with such amazing colleagues, especially Danielle Sokol, whose work I've been reading since I started working in competition, and Thibault, that actually inspired me and my colleague to start researching blockchain. So it's really a huge honor to be here today sharing with you guys this panel. Unfortunately, my partner and former Professor Amanda Taiji couldn't join us today. She's in her maternity leave, and although she intended to join us, let's say predictability is not her best feature in this coronavirus time, so she couldn't be here. It's a pity that you're going to lose her thoughtful remarks. But I'll do my best to try to present our ideas, and yeah, I'll do my best to try to come with her absence. Well, so actually, the idea of this paper, this presentation, is issued from a working paper that will be soon published, I hope, that it started with the idea of mapping the issues that arise from blockchain implementation in international trade and antitrust. But as we were researching, we identified that a lot of aspects in which blockchain benefit or impact international trade also have competition consequences. And because we have experts on the field, we have Thibault on the table today, we thought that would be more beneficial to our discussion to focus our presentation in the international trade aspects, obviously from a competition point of view. So our premise for this paper is that the implementation of blockchain in international trade can help tackle competition issues. And for that, we first point out the implications of blockchain for international trade, how it can be used, and then we try to capture the antitrust concerns that appear throughout this application. And on the second part of this presentation, and also in the second part of the paper, we discussed then the challenges of antitrust when we're dealing with blockchain in international trade. Well, when we're talking about the applications for trade, we talk about a possibility for a paperless area, simplification of the transactional mechanisms, logistics facilitation, quality check, promises for services industry, and here we can talk about different industries, of course. But I chose for this presentation to focus on financial services and e-commerce. We mentioned others on the paper. Intellectual property, possibilities for small and medium enterprises, and public procurement. Well, so to start, paperless era, firstly, the use of this technology of blockchain for commercial transactions could lead to this paperless era. And a variety of documents are needed when we try to conclude international business transactions related to the product or service itself, to the condition of transport, logistics, financing method, customs control, certification of origin, etc. And the whole of this documentary circuit is to link two phases: the logistics and financial of the import-export transaction. The delivery of the goods is documented, and then the goods are going to be paid in exchange of those documents. The use of blockchain could allow, through digitalization of these documents, not only to speed up business transactions, but also to increase the transparency and security. And thus, another expected effect of this use would be a significant reduction of transaction costs. To give you an example of a very important document for international trade that could be digitalized through blockchain is a letter of credit. Well, here I give you an image. You see, I don't have slides as elegant as those of my previous colleagues. I don't know how to make elegant slides. So this is what we're going to do with. So this, we have an image of transactions that are still very analog and document-based, and a possibility using blockchain with very decentralized systems and digital integration. And for example, in letter of credit, this is the most widely used payment method. In its classical version, it involves more than 20 entities in a single procedure, and of course implies enormous number of documents to manage. And the interesting fact is that only 1% of the interaction between all these entities involved actually creates value. So blockchain could digitalize this process and simplify document management, reducing costs. Then we have the whole simplification of the transaction mechanism. Blockchain could basically simplify all these steps of international commercial transactions. And among some advantages for the actors involved in this export-import operations, we have real-time verification of documents, reduced time preparing the delivery of goods, disintermediation, facilitating payment and funding, decentralizing contract execution, reducing the time needed for monitoring, and using proof of ownership, having the bill of landing available in blockchain. And this is another image of what it would look like, global trade using the benefits of blockchain. Now, in terms of logistics, blockchain can be very useful to everything that involves logistics in international trade. I'm referring to packing of goods, loading them into the container, taking them to the port, export, import, customs clearance, and even post-transport unloading of goods. Any issues in logistics can translate in additional costs and harm the image of the entities involved. In a globalized economy, logistics and cost are really important factors for competitiveness and modernization. So the simpler the logistics, the smaller the costs. The application of blockchain in logistic activities can increase transparency, making tracking of goods much easier because all the process will be visible, and can also simplify the management of documents, as well as optimizing supply chain, using Internet of Things to track shipment, for instance. We also have certificates of origin, which are very important documents for international trade, through using the technology of blockchain. And here I would like to talk to you about, for instance, the initiative of in the European Certificate of Origin, that actually the Certificate of Origin is a series of documents that aim to guarantee the shipments of goods were obtained, produced, manufactured, or processed in a certain country. And these are used by governments to determine whether the goods can be legally imported, whether they fall under a quota system, what duties apply, and most importantly, if they qualify for preferential treatment under a specific trade agreement. However, these certificates are very commonly frauded. So these certificates falsely claim that products come from somewhere else in order to benefit from lower tariffs. What blockchain can use is that it can improve transparency, security, and efficiency in this authorizing documents. So a private blockchain distributed ledger, for instance, would track electronic certificates of origin throughout all stages of trade, promising to prevent fraud by providing this ambiguous audit trail and making any alteration of third-party interference immediately apparent. And also I put it here another example of Agility. It's a global provider of logistics solution together with Musk and IBM that designed a blockchain-based solution to manage and track container shipments. So here you have some image just to illustrate supply chain management. And by providing new mechanisms to map the path taken by products, blockchain technologies reviewed a very powerful tool to track supply chains, assisting the fight against piracy and helping to increase consumer confidence in the technology, that it's still, even if it seems very familiar to us, very strange to most part of civilians. Blockchain offers the possibility to trace the origin and destination of products and to validate not only its quality, but also authenticity, and to ensure adequate procedures of production, even fair trade practices. One good example is food supply tracking that provides customers with lots of information regarding the origin of a product. And here we have very clearly a competition issue, that is improved transparency and more information made available in a very easily way to customers. So one example is the IBM Food Trust blockchain. Looks like this. So you can actually track the food from the farmer to retailer and beyond. The customer will have a lot of information on his hand. And one of the big retailers that entered this technology is Carrefour. It began in 2019 when they only tracked 6 projects. And the goal is that in 2022, they will be using this to, implementing this to over 100 products. And it looks like this. So in the package, you have a QR code that you can scan, and then you have access to all the information of that specific product on the whole supply chain. But now, an interesting fact is that if we see all the companies using IBM Food Trust blockchains, we can see only big ones: Carrefour, Unilever, Walmart, Nestle, 3M. But what about the small ones? How really accessible is this kind of technologies for small retainers? Now, moving to service industries, and I told you we can talk about many, but here I'm just going to say a few words on financial services and e-commerce. In case of financial services, we obviously have notably the cryptocurrencies that it is argued that the use of most common blockchain could lead to the disappearance of banks. And the rise of Bitcoins was accompanied, we all know, by an explosion of startups offering payments in cryptocurrencies. That is actually very attractive to international trade whereas the alternative offered by traditional banks often goes by slow mechanisms such as SWIFT. Also, enthusiasts argued that this kind of fintechs could benefit consumers because it's much easily accessible than traditional banks, easier to create a digital identity and open an account. Now, I put here 2 examples of WeTrade and Batavia, that I trade finance consortiums, but I don't want to run out of time, and more antitrust issues follow, so I'm just gonna move on. E-commerce, very simple link here. In the case of online shopping, it is a promised evolution, blockchain and online shopping, especially with cryptocurrencies entering increasingly the market for digital purchases. Now, the WIPO highlights some benefits that could be obtained from using blockchain technology in the treatment of intellectual property. This is because it will be possible to make intellectual property rights much more effective and transparent due to a simpler way of identifying authorship and authenticity. It facilitates the identification of and registration of copyrights and trademarks. There's also a simplification in monitoring the issuance of these patents that would allow them to be done globally. Smart contracts here also offer an interesting option because they can be designed to overcome territorial borders, giving rise to an automatic and unified system of reducing payment for copyrights and licenses. Also, combating piracy is another concern of international trade and competition, and which could be supported by blockchain. Blockchain can strengthen the fight against piracy not only for the riskiest markets, such as pharmaceutical and luxury goods, but also for transport, cars, plane, hospital equipment, thus protecting consumer welfare against, for instance, cartels that might reduce the quality of the products and even put consumers at risk. Now, another use is for SMEs. It's actually a promise. Blockchain technology could provide a new opportunity for small and medium enterprises, especially from developing countries. With improved security and transparency, blockchain facilitates their access to funding. And this was interesting data. 60% of demands for funding or credit from SMEs are rejected, whereas only 7% of those from more traditional firms are rejected. So with improved security or transparency, they could benefit from more investment and funding. By facilitating this access, blockchain facilitates trade proceedings and decrease costs, reducing barriers to entry, especially for small companies. However, there is an important challenge that remains, and that is a costly implementation of adopting this technology. So it's a double-sided thing, because you can benefit of having more players in the market once you already dispose of this technology, but it's also difficult to acquire this technology, difficult for small and medium enterprises. In terms of public procurement, well, we all know that these many opportunities for international trade and also for antitrust can only be exploited as long as the companies and governments have the technical ability to handle the blockchain technology. And it goes the same for us lawyers. We're always talking about the need to improve dialogue between lawyers and programmers. And speaking of our ability to handle and implement the technology, the potential of blockchain to create more effective mechanisms to manage concessions and more transparent models of public procurement is noteworthy. They are costly to implement, but once they're implemented, they really justify the implementation costs. And one example is the Coase district in South Korea. They started using blockchain to reevaluate bid proposals during 2019. It won a prize of the contest for anti-corruption best practices in 2018. And now it is being tested. Depending on its progress, it might be expanded to other local governments in South Korea. Now, as I told you in the beginning, our idea was to see, can blockchain implementation help reduce anti-competitive risks in international trade and possibly other fields? And there's recently a paper co-written by Thibault Chapelle that can talk about it later, I hope, called Blockchain Code as Antitrust. I was reading and discussing with my partner last week about it. And basically, he says about this possibility that blockchain would help or supplement antitrust instead of replacing it. So we should see it as an ally. And here I found it very interesting because we can see a lot of actually helpful ways of tackling competition issues by the use of blockchain in international trade. Now, of course, we have pros and cons, and we just started touching the issue. It's not very common that we see these two topics associated. So some pros, for instance, to support this hypothesis is that we have more options and more information available to customers, new opportunities for SMEs, more players in the market, a more transparent public procurement system, improved intellectual property registration methods, etc. But on the cons, we have a costly implementation that might actually reduce possibilities of new entrants. Private blockchain that can increase power and might favor collusive behavior among the participants. So our classics antitrust issues with blockchain. And for instance, this new food tracking system, are they actually a benefit to consumer because we offer all these possibilities, all this information available to them, or it's actually a barrier of entrance that cannot take part in this blockchain? Well, these are some of the reflections that we wanted to highlight for this presentation, and thank you very much. I'm looking forward to your comments.
Great, thank you. So I thought that was very helpful in a number of ways, very synergistic with the prior presentation. Once again, we'll go with questions to anybody because we don't have a hand raising. I will just invite you in the Zoom chat to just type in your name, say, I have a question, and you will be called on. And Nicolas, we'll have you go first because you asked before. And then, let's see, Katarina, you'll go next. And I'm looking for anybody else to ask questions after that. So say who you are, your affiliation, and who your question is for. And it could be for multiple people. For all I know, you also have multiple affiliations. Nicolas.
Thank you, Danny. And thanks to all for a great session. So I really have a question, not really a comment. And the question is for Thibault and Julia. So I sense a lot of synergies with the work that I'm trying to do myself in terms of thinking about these sort of screens that prevent competition law and policy to get deeper into the empirical understanding of organizations like firms. And so I was wondering, and that's, for the community here, what kind of fields as scholars would you look at to improve our understanding of the complex mechanics of organizations like firms, which operate in markets and which very often have impacts, as you showed in your presentations, on markets outcomes and business conduct. And so I wonder if you could provide suggestions for future research and suggested literature to consult and investigate to move a little the boundary and not stay stuck into this level of aggregation or unit of aggregation that we use in antitrust, which is the firm in the markets. I hope Danny likes the question.
So, who wants?
I do. It's a great question.
Okay, if I may, I was about to say it's pretty funny because I'm sure that Danny is dying to answer your question, because I remember seeing somewhere, I think on your blog, Danny, that you were saying that in the field of antitrust we tend to be stuck with our own literature, and you were when you mentioned worth downloading on a few papers, I noticed generally it's coming from another field. So I'm sure you would like to answer the question, so maybe you could as well. But if I may, on my side,
this is a connecting platform, like a social media platform. I'm just the intermediary. This is your show, every one of you who presented.
Yes, but you know, platform liability and everything. So, but yeah, I mean, again, I agree with that perspective that if we get stuck in the field of antitrust, it's, you know, we will address some problems which are not real problems or maybe not so important. So I would say one field is the field of management science, and everything that relates to the organization of the firm. And for that, obviously the work, and I haven't mentioned Williamson, who unfortunately passed away a month ago, but obviously the work on Williamson is key. I could mention also Langlois or of course Richard Thies. And so that goes for understanding how the firm is managing technology and innovation and the behavior of the firm. But also on the tech side, you know, it's funny because it's very cool to be a blockchain skeptic. I always wonder, where are the internet skeptic? You know, back in the days, probably we had a few, but now we have the blockchain skeptic, and I'm somehow a different sort of skeptic. I'd say that I'm skeptic if I open a paper of law and technology, whether it is antitrust or another one, and I only see references to the literature of that field. And I think, and I really encourage everyone to go to websites such as Medium, for instance. I think Medium is great because the tech community could actually write right away what they think are the issues, but also TechCrunch. You could also go to the MIT Tech Review. And if we discuss blockchain, you have to read Decrypt, you have to read the Cointelegraph, the CoinDesk. And if I open a paper and if I don't see any of those, I tend to I ask myself the question, all right, are we answering the right questions, or are we just answering the questions that we think are the questions that the courts thought were the right questions? So again, both those two pillars, management and the technology, I think that's what you need to enter the firm black box or the blockchain black box, whatever that is. But our level of antitrust analysis, I think we've come to an end. We're going to get stuck and keep on repeating the same forever.
Great, thank you. Let's see. Katarina, we have you next, followed by Jasper.
Are you calling Christina maybe? Or Katerina?
No, Katarina.
Oh.
Oh, who has, Katarina, you're on mute.
Sorry. Excuse me. Here I am. Yes.
No, I think it's me, right? I had a question for Thibaut. I'm Katerina as well.
Okay, I'm sorry. So I'm off again. Just me.
No, I have a comment for Thibaut, and I'm sorry, Thibaut, because I'm coming here from a very legal perspective, and I'll be a bit old school about this. But in terms of the theory of the firm, as you know, it's true that you mentioned Roald Coase work, and it's very old, dating from the 30s. It's true that in the 70s it's when it started getting attention, and after that there are many theories of the firm. You mentioned Williamson, property rights theory, contractarian theory, and many authors see, although these theories, they point in different aspects of what define the firm and how to define the boundaries, but the element of control seems to be present, or the possibility of exercising control seems to be present in all these theories. That's one comment. And another comment is that I have an issue when you say that antitrust rules apply to a legal fiction. Yes, it's true that so the subjects of competition law, yes, there are undertakings, but legal personality still plays a very important role here, because when the commission addresses a decision, it has to be to a legal person. And so, you know, yes, we can attribute liability to one entity for the behavior of another, but we have to do this in a legal structure. And so we have to find a connecting point and the court has been using control so far, and which kind of seems backed up by economic theory, but that's it.
I mean, yeah, very briefly. I mean, I think we agree. I mean, I agree with you that maybe it's the term fiction which could be a bit negative, but indeed, and you do have some literature saying that we are, of course, as person we exist, but our person in the legal system is also a part of a legal fiction, and so is the legal person for a firm. So yes, we do apply the law to those legal fiction, and that's why I think we should think about that concept when it comes to blockchain. And it's, I never thought of it for the first comments. I never thought of it this way. It's true that control is more or less present for all of them, but I'm thinking, for instance, the theories of Michael Jensen, where it's more, it sees the firm as a nexus of contract. So of course, in a contract, you do have a control relationship, but it seems to fit a bit more to what the blockchain is, because of course you do have control between a few participants, but you cannot control the whole. So indeed, I think you're right. It's worth exploring whether or not there are other theories which are not focusing on control. But in any case, in antitrust, so far we've been focusing on Coase, and Coase is quite it's quite vertical control-ish. So indeed, that's why it doesn't fit well with blockchain, which was designed for the lack of control.
Okay, great. All, and then Jasper.
Yeah, thank you. So I had a question for the first paper of Lara and Christina. My question, it's a common question. It's about the idea of experimentalism. So if you look at the negotiations and draft papers of the member states and of the Commission prior to the adoption of Regulation 1/2003, you can see that actually the idea of sandboxing and experimentalism was a core value. So my question is it something you take into account? Do you think the definitions given there are relevant to your research?
I don't know if Christina is willing to answer. I think it's a very interesting comment. Thank you all. I think we can find good food for thought. The only concern I see is that we focus our research on fintech regulatory sandboxes. So the definition is evolving quite fast, and we should distinguish between, this debate that is very relevant, but is linked more to, let's say, traditional categories. But thank you. That's a very helpful comment.
Yeah. We started by focusing on a case of sandboxes, but we now are considering if this could be an approach for competition. So we start trying to design the framework, so to see previous work on the two, competition and experimentalism, to look at the direction of these studies, but we are considering for new cases to see if this could be a general approach.
Did you look at Jonathan Zeitling's work? Okay.
Yeah.
And also on competition?
Yeah,
okay.
Exactly.
It was in one of the slides.
Sorry, then I missed that slide.
This is much more about this form of dynamic and deliberative cooperation and tentative cooperation among competition authorities. So our case of sandboxes is quite different, or could fit within such a framework. So this is something that we are considering. Yeah. Thank you. Very useful question.
Okay, given that there's a bit of a queue, this is what we're going to do. So it actually builds, Christina, on your paper. You'll appreciate this. How are we dealing with it? In a very flexible way. I'm going to have everybody ask their questions, so we'll get all of the questions out, and that way for sure we'll be able to get that. And if there is time, then we'll allow the presenters to respond. So Jasper, followed by Miguel, followed by Julia, who has a comment for everyone, and we'll see if we have time after that. So just questions.
All right, thanks, Danny, and thanks to all the panel participants for putting a wonderful panel together. My question is for Laura and Christina. It's two-pronged, actually. Wonderful paper, and really good of you to draw attention to this from the regulatory scene to the competition law scene. However, I would like to challenge you a little on the supposed benefits of being in the sandbox. You seem to assume that there's only benefits to being in the sandbox, and I'm not sure. There might also be disadvantages that are worth discussing. And then second, it might be interesting to connect your entry barriers point to a public procurement law and see if public procurement law could actually be helpful in setting up a just and level playing field access to the sandbox. Thank you.
Thank you. And my question is complementary to Jasper's. It has to do with the institutional setting. Aren't you afraid that entrusting the issue of defining and determining access to these regulatory sandboxes to regulators might lead to capture by the sort of first comers that will then influence the way regulation will take place later on? I'm particularly scared of central banks because they do tend to be a bit cozier with the incumbents. Thank you.
Great. Next is Julia, or is it Julia?
It's Julia, yes.
Okay,
thank
Julia.
you. Well, so first question, first let me comment a little bit on Nicolas Petit's question. I think that, and it's a little bit of we are all discussing today, we focus too much, especially when we're discussing digital innovation, on the antitrust field. And anytime we can integrate this dialogue with other fields of study, even other law fields, I think it's beneficial. So I would, I also worked with corporate law for a while, so I would use the insights that we can take from traditional literature of corporate law to steal something of that when we are thinking about firms and how to regulate them in antitrust. And so I have a question for Vela and also for Thibaut. I think they are in a way similar. To Vela is, have you seen in any places some initiatives that try to allow or erase the monopoly of lawyers to provide legal services? Have you seen some active improvements in that way, or some sort of trial use of that? And to Thibaut, because you just said about legal fiction and all that, is this the time of when you mentioned going outside of legal, going outside of the law? You say that, so we go outside and pick some things and pick some of their ideas of other fields of science and then go back to antitrust, or more in the way of Vela, that means enable other types of provider, not only lawyers, to provide legal services and use this type of digital platforms. And that's it.
Okay. If there are no other questions in the queue, I will let people answer in turn among the different speakers. Are there any other questions? This is your last chance, and at this point you could just interject, but make sure to unmute yourself. Yes, Andres, I see a hand. Oh, apparently we do have hand options. Okay, Andres.
Yes, I was asking Thibaut that if he thinks that we should move away from the theory of the firm or antitrust using blockchain as an example, we should do it as well with the current theories of liability.
Okay. If I see no other questions, I will allow our participants to, I guess, go in order based on whichever question they want to answer first. Keep your answer short because we had a series of questions and a few of you had questions for each other.
So maybe, can I quickly address our questions?
Yes, absolutely.
So they are all very useful, in my opinion, for our research. So thank you, and maybe we will answer via email, maybe. I agree with you, Gasper. There are also possible negative effect in being part of a sandbox, even if, and this is linked to Miguel's comment, being outside the, let's say, sandbox, which is setting the ground for a regulation, could be, let's say, a more disadvantage point than, you know, deciding to be inside and accepting few conditions that can provoke negative effects. And very quickly, yes, totally agree with Miguel that we risk to have a too high influence from players, and in particular central banks, and this is a risk we should address in the fintech sector. However, I think this is a risk we already face also without regulatory sandboxes, also in the general regulation sector. I was very quick, maybe I would be happy to discuss further with you via email and so on. I don't know if Christina has something to add to our answer.
No, I share your views. It's okay.
Great. Somebody else want to jump in with an answer to one of the questions they were posed?
Okay, maybe I should answer my question. So in regard to your question, legal technology has been adopted by lawyers in so many ways, but what is normally done is that legal technology is used to support legal services. For example, legal research, documentation review, or predictive analysis. But one of the areas that has been developed very well is in regard to the US, where the US Supreme Court has really played a great role when the bar associations go to court and argue that the legal startups cannot do documentation or provide certain services to the people. And I think that kind of demarcation, for example, there is a case of Lola versus Caden. I can share the decision and also an article that was written about that, that particular issue, whereby the judge said that unauthorized practice of law is not meant to protect lawyers from competition, but it's meant to ensure that consumers are able to access justice. And if I quote the lawyers, the judge said that tasks that could otherwise be performed by machines cannot be said to fall under the practice of law. So when we are having such a demarcation about services, legal tasks that can be done by machines and those that can be done by the human lawyer, then it's really creating a healthy competition and protecting the consumers also, and ensuring that they're accessing some of these tools. Yeah. And also another thing that has also evolved from this course is trying to say that we are looking at restrictions in the legal market that are necessary, that are justifiable in meeting the public good of consumers. So if such measures are not justifiable, but they're only to expand monopoly, then in most cases, the courts will literally say that is not the way to go. But this development is happening more in the developed regions. So that's why I'm bringing in the developing countries story so that we can understand what is happening this other side. Yeah. Thank you.
Thibaut, and then we'll let Julia finish off the session.
Sure. So I'll be brief. I don't recall the question, but I have some notes for my answer, so I hope it works. I think we have to start from reality, and I do feel that sometimes this is not where we are starting in the field of antitrust. We start from reading a legal decision and then concerns from the courts, and of course sometimes it could be the real concerns in the market. But I do believe that if we start from reality and looking at, you know, if you read TechCrunch newsletter, all the news coming from the Silicon Valley, you could identify lots of practices which seems to be recurrent and never being addressed by competition agencies. But in the end, in the way we could interact, I think it's really code and the law that could be combined to reach a certain result. So again, I don't recall your question exactly, but more than happy to discuss that after the session. For Andres, I mean, indeed, that's the point, right? That's that's what we all care about, which is liability. In the end, who's paying how much, right? It's all about money. So the theory of the firm and all that, and what's the entity and what's the practice, in the end, the question that matters is who's paying for that. And so indeed, if you are moving from the theory of the firm, you move away from the liability that goes with it. And because blockchain is not entering that theory, there is no way to assign liability to the layer 1 of blockchain, which is why I think we need to have a new theory. And something I want to mention very briefly is that indeed, you will assign liability to a few participants in the blockchain, but it also means that it will protect them where they have no control. They could prove have no control, therefore no liability. So I think this is a win-win situation. And in 2 seconds, I've seen a question in the chat by Anush. What I mean by entering the firm, again, is 2 things. The first is to enter the firm to see what is control, exactly what's happening within the firm, which type of decision it could lead, something that I've been writing about, to studying predatory innovation and try to understand the negative aspect from within, but also the positive aspect. And for that, if firms express internally that they feel the pressure from another one coming from a different market, I think this is valuable information for competition agencies. And this is a type of information you won't get if you just look at the market from above. So this is what I meant.
Okay, Julia, we'll let you conclude with thoughts to any of the general questions or your specific question.
Okay, thank you. I don't think there's any questions left, but maybe some thoughts that just to elaborate on what Thibaut answered to me. I think that specifically when discussing innovation and everything that, especially blockchain, that can seem a little bit of an alien to us lawyers, we really need to start from reality. And what I tried to do in the presentation, also in the paper, was to look at very concrete examples that are easily understandable, that affect everybody's everyday people's lives, not only in financial services, things that are hardly seeable. For instance, in all the track supply system that I showed you, the QR code that tracks the products in supermarkets. So I think that's a good approach to see how it actually impacts people's lives. And I think that's also what Vale tried to do with her paper when studying specifically the conditions of developing economies. So I think this is a very interdisciplinary approach of discussing a competition in a specific market. And it was very pleasant for me. I think it was very enriching for all of us.
May I quickly say something?
Absolutely.
30 seconds. I mean, I think this is, and I'll be curious to have your opinion, but it seems that this is the approach that we all adopted, right? To start from reality. Which type of sandboxes do you need from a practical point of view? What's technology is doing to lawyers? Exactly. What does it mean? And I feel in the minority doing that. And when I started writing with Vitalik, it was funny because he said in my email, but sometimes the law don't apply. Chinese companies cannot actually enforce the law on US soil and vice versa, or it's very complex. So what technology could do for those companies? And for me as a lawyer, to start from a perspective, okay, let's write a paper outside the rule of law, was something very disruptive. But again, I think this is why we have to start from reality and to engage. And you know, sometimes when I discuss with blockchain developers, they just launched a new startup, and they come to me and they say, oh, you do antitrust? Well, I've heard about those cases. I'm afraid I'm going to be in the dominant position. What should I do? And I really think that's a shame, that they have to think about a dominant position 2 weeks after starting, launching a new product. So somehow we have to find a way to do things differently. Otherwise, we are creating negative effects and not being able to see them, which is a shame. So more than happy to hear your thoughts on what you think in terms of that reality perspective.
That's a great place to end because the next session begins now. So Team Zurich, Katarina, I have a question for you. Do we stay here or do we move somewhere else?
I just shared the link in the comments. Because it is the team Düsseldorf who is hosting the next part. So the panel tips
great.
for young academics.
Okay, thank you all.
Thank you all.
Thank you.
Goodbye.
Goodbye. Thank you all. Ciao.